Hello, everyone, and welcome. Okay, so we got Lori and Chad in court this morning. Court has already started. It's not being streamed, but I have the information that what is going on. I have it coming live out of the courtroom so I can let you guys all know. Good morning, everybody. Dawn, Susie, Judy, Kat H. Hello, and welcome. Okay, so Lori and Chad are both at court today. Both going to be in the courtroom at the same time. So what I'm getting coming out of the courtroom, like I said, it's already started. So I'm going to bring you guys up to date. Okay, so right now the information that's out there. Hello, CSI, Susie, Susan. Hello. So sufficient evidence exists for the grand jury to find probable cause that the defendant intended for her children and Tammy Daybell to die. There is sufficient evidence for a jury to conclude she participated in the killings of her own children. That's what the prosecution has responded to the defendant's motions that they filed in the court. So both Lori and Chad are in court. It's a death penalty case. Chad has asked for a continuance. And Lori has asked for a meeting and asked for that she is not going to be, for her not to be classified as death penalty eligible and all that shit. It's all going to be talked about today. So it's already started. So let me get you up to date. Also, they're going to address jury, sequestering the jury is also on the agenda for today. The prosecution wants the jury sequestered and both defense does not. Chad's in the courtroom wearing a white shirt and tie. Lori at the time of this was not there yet. Courtroom is set up with 3 tables in an L shape. Lori and Chad at separate tables next to each other with their lawyers. Prosecutors are at the other table. They were still waiting on Lori. So Lori finally gets there. She entered the courtroom wearing a pink blouse and a black dress pants. She has a red lipstick on and her hair is all curled up. She looks over at Chad as she enters. Chad's in a white shirt and tie and has been looking straight ahead. So John Pryor, Chad Daybell's attorney, starts off. He's arguing the trial needs to be pushed back because he's waiting on DNA evidence. He says, it's evidence I need and want to use in support of my case, and I'm entitled to it. He also said he doesn't know when he will get the evidence and needs more time. John Pryor also says, even if DNA is provided to me tomorrow, I'm going to need time to have my expert test it and make their own conclusions. Pryor doesn't blame the prosecutors for the delay and says it's the state's experts who aren't finding the evidence and disclosing it in a proper manner. Good morning, everybody. Phyllis, Glamma D, good morning. Scout, good morning. And hugs right back from Canada to you, right back to you in New York. Okay, so February 23rd is the deadline for evidence to be disclosed to all parties. Pryor is saying that even if he gets the new DNA evidence tomorrow, that he doesn't have enough time to analyze and prepare before the trial, which is set to begin on April 3rd. So Pryor's also saying now, if I don't get that evidence, Mr. Daybell is going to file an ineffective counsel against me. As much as I like Chad, he is going to do it, and he won't hesitate to do it. Then this case will be turned over because I wasn't provided an opportunity to adequately prepare. So now he's making threats to the court. It's like, your guys are going to have to start all over. If Chad fires me saying I'm ineffective and blah, 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 he could fire me and you guys are going to have to start all over with a new lawyer. So it's kind of like he's giving ultimatums here, and I don't think that should go over well with the court. Stay-at-home mom detective, good morning. Okay, so Prosecutor Lindsay Blake is now responding to Pryor's argument. She says the court has been made aware of the outstanding DNA. We've talked about the efforts to get it.
Even with that going on, the defendant was initially insistent that the trial take place in January 2023. Now, we went over all that in the last filings, where the prosecution wanted to wait until late fall of 2023, but for the trial to start. But John Pryor was adamant, I want it to start January 2023. I'm going to be ready to go, blah, 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 blah. And then it was put off now until April. So that gives him an additional 3 months, right? So that's what she's arguing. And she says that Pryor has been aware of the outstanding discovery evidence when he said at the last motion to continue that he would be ready for trial in January 2023. The judge is asking Blake, who is the prosecuting attorney, is there exculpatory evidence that has not been disclosed? Blake says there was a potential source of DNA evidence that was located. The state lab personnel does not believe, though, through testing, that they are going to get any DNA back from it. Could it be exculpatory? We don't know. Blake says Pryor is welcome to test the evidence that the crime lab is testing. Blake is responding to Pryor's statement about the case being overturned. She says it's an erroneous conclusion that if he proceeds to trial and evidence is not allowed in, it would automatically result in a new trial. There's a lot more that needs to be looked at. Pryor said that he was ready for the trial when he previously said he would be ready, but has since learned about the additional evidence and other grand jury convening that involved witnesses in Chad's case. Details of the other grand jury have not been made public. So there was another grand jury that was held. We do know from the previous filings that I have showed you guys that they do have the grand jury transcript now. Pryor and the other defense team does have that filing. And they were also made aware, apparently last year, of this new hair evidence. So they knew that it was there, but they still insisted that they could go ahead with this trial in January. Then because of Lori's little episode there of whatever happened, I think it was just needing her meds adjusted, that now it's put off till April. Now, the thing is with this, you guys, is Lori has not waived her right to a speedy trial. Hello, Sarah. Hello, GP, Jean P, Jody. Hello, everybody coming in. Please smash that like button on your way in. We got 74 people in here, 78, only 27 likes. It's free to do. Please smash that like button. It helps to support the channel. Under your scars. Hello, hello. Okay, so like I said, Lori has not waived her right to a speedy trial. So she was entitled to have her trial back in October of 2022. Being that January 2023 wasn't far off and it gave her lawyers a little bit more time, I guess she agreed to it. Please, thank you for smashing the like button, all you guys. Thank you, thank you. I appreciate it. It's free to do. Super chats and everything are always welcome, but this is a free way for you guys to help support the channel and show your appreciation too. And it's free to do. So is subscribing. So now that they moved it from January to April, I think both sides are really playing with that, because if they keep putting it out over and over, she has a constitutional right to a speedy trial. She did not waive it where Chad did. This could be setting Lori up to have her case thrown out. And that's what we don't want, you guys. Okay. So as far as Chad, he's continuing to face forward. He hasn't looked at Lori once, and Lori keeps glancing over at Chad. Don't forget, they're going to be talking to here, you guys, about this little rendezvous that they want to have together with no recordings and everything else. Yes, and Gene P says exactly. I said that a couple days ago when we went over the court documents. John Pryor is doing everything he can to get this trial severed, whereas the prosecution still wants to keep them joined. But now they're going to run a risk of Lori's case being thrown out because she did not waive her right to a speedy trial. If this does not go through in April, then they run a chance of Lori getting her case thrown out, okay, for the violation of her rights to a speedy trial. And then Chad is on his own. Now, the only thing that I can see happening, we're going to continue because there's more coming through here. The only thing that they can do at this point, if the judge agrees to put this trial off again until the fall for Chad, they have to either sever it or Lori's charges are going to be thrown out. I mean, they're going to have reason to do that, her defense team, because of her right to a speedy trial being breached. Okay, let's see what else is going on here. Okay, so Pryor is concluding his rebuttal. Blake asks for a sidebar with the judge. Boyce denies the request and says he's ready to rule on Pryor's request to continue, which means to delay the trial. Hang on a sec, you guys. Okay, it looks like Judge Boyce is going to make this decision right now. So Boyce is saying Mr. Pryor has been representing Mr. Daybell since June 12th, 2020. This trial in this case was scheduled originally for November 8th, 2021. Then it was rescheduled again because of delays of competency issues, and we set it out to January 9th, 2023, which would have been in trial now. Overarching concern is that one defendant, Mr. Daybell, is requesting to have it set out another year. The co-defendant has unequivocally asserted her right to a speedy trial. She has never waived about wanting these things to go on without delay. So Boyce continues, the trial is going to go forward in April of 2023. I can't push it out any further because Lori Daybell has not waived her right to a speedy trial. There you go. And that's exactly what I thought he was going to do. John Pryor was trying to give the judge basically an ultimatum and threaten the court type thing in a roundabout way that I'm not going to have time to prepare. Now this new hair evidence, blah, blah, blah. I could very well be fired. So you're going to have to start all over again and get a new trial and all this crap. The judge isn't buying it. He's finally putting his foot down here. I think John Pryor has been really used to getting his way. Boyce is denying Chad Daybell's request to continue the trial, but says that it is premised on speedy trial rights expressed by co-defendant Lori Vallow Daybell. So he's saying that he is making this decision because Lori Vallow is entitled to her speedy trial. And by putting this out, that's going to go against her rights. So there you go. The judge is finally putting, okay, we got a lot more to go through here, you guys. There's a lot more motions. Boyce says, if we are still up on the eve of the trial, uh-oh. Let me just read through this before I read it out loud. Oh no. Okay, so what Boyce is saying right now is if we are still up on the eve of the trial and the state has exculpatory evidence and did not provide Pryor enough time, at that point, the case may be severed. Boyce says he's not going to force Chad Daybell into trial if he hasn't had enough time to examine exculpatory evidence. So I do see this probably being severed. He's going to get what he wants. Next item on the agenda is regarding sequestration of the jury. The prosecution wants the jury sequestered. Both the defense teams do not. Rachel Smith is arguing the motion on behalf of the prosecution. Yeah. Gene P, it's not, let me just let it come up over here. The DA is not holding back anything. It's the lab.
So let's not jump on the DA right now. They have provided everything except for there was hair that the lab found on something, either like we were talking about. If you haven't seen my last video on this, when I went over the paperwork, you guys, it was just a day or so ago. Go check it out. I go over this there. And what I'm saying is it depends on where these hairs were found that are new, right? That were just found, I think, back in, I think they said October, that the lab found on something or in something. That could be, and I gave some examples, that could be hair that was on one of the items used to murder the children. It could have been found in that red shed on Chad's property. It could have been found 4 feet, 5 feet, 6 feet underground with the bodies, which would be a hard thing to explain away why this hair is underground, right? If it belongs to Chad or Lori. It could be hair that was found stuck to a garbage bag, inside one of those bags on the duct tape. It could be anything at this point, you guys. Good for the prosecution would be that there was one of Lori's hairs or something found mixed with the blood on one of those tools. You know what I mean? That were used to dismember Tylee, sorry. So this is not on the DA right now, you guys. I may do that, Kelly B. If they sever it, Lori's case is going to go ahead on April 3rd, and Chad's will be set out at a later date. Absolutely. They want to be able to test if there's any DNA that's been extracted from these hairs. If there is enough of a sample there, the defense wants half to test. If there's nothing there and they can't get any DNA from it, then this goes forward. Okay. The judge worded that really, really good, because what he's saying is the only way that this is going to be severed is if there is exculpatory evidence that has not been provided. Exculpatory means something that could be good for the defense. Okay. So if there's no DNA taken or gotten from these samples, then both of them go ahead on April 3rd. Okay, so here we go. The next item on the agenda, okay, is sequestering of the jury. Rachel Smith is arguing this point. Smith says, we are very worried given the nature of this case, given the publicity in this case, that if the court does not sequester the jury for the duration of the trial, there will be problems keeping juries secure and making them have no contact from parties about this case. So which means making sure they don't read news reports, stuff that's coming out of the courtroom, anything out in social media that may sway their judgment, stuff like that. She continues by saying, this is the district attorney talking, Rachel Smith. We have concerns that if a jury has contact from third parties and they consider outside factors, it violates both defendants' right to a fair trial. We recognize it's a lot of money. We also recognize it's a real hardship and challenge for individuals. Yes, I think that they will have that back and they will have more than enough time. Okay, Kelly, we're not going to, we're not going to talk about other reads or anything like that here, please. I'm removing that comment. We're keeping it factual. That's all I do here. I don't talk about anybody else's reads or information or anything like that here. So let's keep it to what we're talking about here, please. Thank you, Sarah. Sarah Rubel. Thank you. Thank you so much. Oh yeah, Chad is not interested, I don't think, in any kind of crap with Lori. Don't forget, we still got that we're talking right now about jury sequestering the jury for the whole trial. Don't forget, the judge is also going to rule on this little powwow that Lori wants to have alone with Chad, with no cameras, no recording, no nothing. We're still going to be hearing about that too. I don't know, Dawn, if Chad is on board with that. We're going to find out as this goes on. Okay, so Jim Archibald, Lori's attorney, says he would typically agree with the state on a high-profile case to have the jury sequestered. This is jury sequestered in this, but his concern is having the jury away from family and friends for 2 months. Hello, Lorna, Sarah. Hello, Melmac. Kelly B. Everybody coming in. Hello, hello. Susan Oswald. Hello. He says it's going to limit, this is Archibald speaking now. He says it's going to limit our jury pool. Our jury pool is going to consist of who? Retirees, nobody with a job, nobody with a business to run. He says we'd rather have a jury that represents a cross-section of the community, so we respectively reject the motion to sequester. I agree, Melmac. Chad could hardly wait to tap that loaded woman's, but now can't drop her fast enough. I agree. Hey, Kimmy. Okay, so Archibald is saying that he doesn't want the jury sequestered either for the full trial. Chad Daybell continues to face forward, not even looking at his own attorney next to him when he speaks, whereas Lori is looking around the room at whoever is speaking. She keeps looking over at Chad, and he's not giving her the time of day. So Pryor is also objecting to sequestering the jury. He says, we can't get around the fact there's publicity. I trust the Ada County and Fremont County sheriffs are going to be able to provide adequate amounts of security for the jurors. Well, I don't agree with that really, because they can't watch over them while they're in their own homes and stuff like that. They can get on iPads and everything else and look what everybody's saying, right? Okay, so Pryor also says the only thing the only thing it would do is stopping a bunch of jurors from reading the paper or getting on the internet. You can instruct them about that, Judge. You don't need to lock up a jury for 2 months like prisoners. So that's Chad Daybell's lawyer, and it looks like Boyce is going to be ruling on everything today. Okay, so Boyce, the judge, he says he's had a long time to think about sequestering of a jury. I share some of the concerns about the hardships on whether you can come up with a cross-section of society if a jury is sequestered. Boyce denies the request to sequester the jury. He says he's ruling on everything today, you guys. He's ruling on everything. The judge says, I believe adequate steps can be put into place to not require the jury to be sequestered during the course of the trial, and the court will take those steps very seriously. Okay, so next up is going to be this powwow that they want to have together, right? Lori filed a motion, as we all know, if you've seen my last video on this. Lori filed a motion that she wants this joint settlement meeting, and by law, if we go into the legal aspects of it, hang on a sec, you guys. Yeah, okay. So she wants to have this secret powwow with Chad where they can talk in private, where there's no cameras, no guards in the room, no recording of their conversation. Now, they're not entitled to that. Now, if the prosecution had offered a deal, then they would have a right to have a powwow with their lawyers and this and that. But to just say that, you know, our lawyers will be there and we just want to talk amongst each other freely without having this recorded and everything else, well, that in turns their lawyers into witnesses for the prosecution, because that's not privileged. Okay. So anything they say to each other after arrest is not privileged. Okay, so the next step, the motion of the joint settlement and strategy session filed by Lori Vallow Daybell. She wants to have a face-to-face meeting and phone calls. Oh, she wants to be able to have phone calls with Chad Daybell too, without those being recorded. Jim Archibald, which is Lori's, no, the jury will not be sequestered, Dawn. Okay, so Lori's lawyer now is says there have been settlement offers. Oh, really? We haven't heard of any settlement offers. So Archibald is saying that there have been settlement offers and the two defendants would like to be able to talk about their options in the settlement. This is an unusual to make a request like this. Typically, the law enforcement wants defendants to stay apart while their cases are pending. Archibald said there are over 100 witnesses in this case. All of them can talk to each other except Chad and Lori can't talk with each other. Archibald says we need to be able to talk settlement and a plan strategy. As we prepare for settlement conferences, as we prepare for, he says medication, but I think it's mediation, I'm asking for an order from the court and I'd like it to start today, which means that the jail and that can't record any conversations that they have on the phone, that they can have in-person meetings together with no cameras, no audio, no video, no nothing recording, and they can say whatever they want back and forth to each other. I can't see the prosecution wanting this at all, because usually when you've got co-defendants, you don't want them being able to speak to each other, come up with a plan. Okay, look at, now that we've seen the evidence, this is what we can say about this. This is how we can get out of this. This is, you know what I mean? Archibald says we need, Archibald says, after our court hearings today, I'd like an order from the court that we are allowed to spend 30 minutes together in a jury room, Lori and Chad and their attorneys. This is an important issue for my client. So they want that today once this hearing is over. They want to go into the jury room and they want to be able to have a secret conversation. The two attorneys, Lori and Chad. Well, what that does is that opens it up for the prosecution to call their lawyers as witnesses. Okay, so Archibald is saying it's an important issue for his client, and they want it today after this hearing in the jury room. Archibald says we can have a sheriff outside the door to guard the clients and attorney from people trying to listen in, people trying to get access. Lindsay Blake is going to argue this, you guys. Okay, so Lindsay Blake is arguing on behalf of the state. She says they have several concerns about this request. She says each defendant has an attorney-client privilege with their respective counsel. They do not have that same privilege with their co-defendant's counsel. That's what I was just talking about. They're opening themselves up to be called as witnesses. Blake says there can be no settlement conference if the state is not a party to that. The request is to not have the state present, so there could be no settlement negotiations unless the state is there. Oh, Gene P, thank you so much. I appreciate that. Oh, thank you. That really helps the channel out, so I appreciate any of the super chats, super stickers. Thank you. Okay, so Pryor is now addressing the request to have Chad and Lori meet. If you hear a little bit of banging there, you guys, I'm having sips of coffee, so I'm not coughing up a storm here. I really need to quit smoking, you guys. Okay, so Mr. Daybell, this is John Pryor now. Yes, thank you very much, Gene P. I appreciate it. Deborah, thank you, Deborah. Thank you so much for your super sticker. I appreciate that very much. You guys are awesome. It helps keep the channel going, you guys, and shows appreciation. So thank you. I really appreciate that. Okay, so John Pryor now is addressing the request to have Chad and Lori meet. He says, Mr. Daybell and I are going to present a defense. I took issue with the word strategizing. Mr. Archibald's motion used in his pleadings. He said, I'm not going to strategize with anybody. I'm going to present our defense. Ooh, Mr. John Pryor is basically, that was like a slap in the face to Jim Archibald. It's like, I don't know why you're using that language, bud, but that's not what I'm going to do. There's no strategizing. I'm going to present our defense, and you strategize with that basically all you want. Oh my gosh. He says these meetings are going to help. These meetings are going to be trial prep. There's going to be no strategizing. This is a trial prep. Ooh, thank you, Kimmy. Thank you. He said at this point, okay, this is still John Pryor. Okay, wait. He says these meetings are going to be trial prep. So you can't ask for a face-to-face meeting to prepare for a trial. You can't. Each attorney has attorney-client privilege with their own client. That does not extend to your co-defendant. So anything, okay, let's say it this way. Hang on a sec. Kelly B. Thank you so much, Kelly B. I appreciate you. Thank you. So what I'm saying is, if John Pryor is sitting in a room with Lori and Chad, he doesn't have to comment or talk about anything Chad says, but he's opening up himself to being called as a witness in what Lori says. And the same with Lori's lawyer. There's a client attorney privilege between Jim Archibald and Lori, but not Jim and Chad. So he could be called as a witness as to what Chad said. And bet your boots, the prosecution will call them as witnesses. Sorry for the cough, you guys. This is ridiculous. Thank you again, Kelly B. Deborah Barlow, GP, thank you, you guys. GP started the choo-choo train. Thank you. Thank you, you guys. You guys are awesome. So Pryor is saying at this point, we aren't going to waver from the true and accurate facts of this case. I'm not going to engage with Ms. Vallow Daybell in terms of taking a plea offer. I find that inappropriate, and I'm not going to engage in that. So Pryor knows any conversation that is had in that room, he only has to keep what he and Chad talk about. He can't speak on that. It's client, attorney privilege. But anything Lori says, you bet your boots he's going to use that, and he's going to use that in his defense also. So what he's saying here is, I not only know that now I can use what Lori says, I know that the other side, Lori's side, can use what Chad says, and he ain't going to have no part of that. Okay, that's what he said. If you're breaking down exactly what he is saying, that's what he's saying. He's saying, I know what could happen here, and we can be called as witnesses against each other's client, right? Yes, I know, Kelly B. I wish I could. It's just the stress, right? Yes, I am doing a lot better. Like I said, I had one hell of a cold. I don't know if it was a COVID or whatever. I don't think it was COVID, but right now it's still really congested in the lungs. But my sinuses have finally cleared out and all that. So I don't know if I did have maybe a touch of that. I don't know. But yeah, I am doing a lot better. So thank you, DJ O, for acknowledging that. Thank you. It's almost done, you guys. So I'm feeling a lot better. So John Pryor right here is putting it all out there. It's like, I see what could happen here, and I ain't playing that game, right? Blake now is offering a rebuttal. She says, we still have not heard one reason why the defendants themselves need to meet face to face. In addition to that, the defendants' respective counsel is not even in agreement about why they need to meet. So Archibald is asking if he can provide some context for his request. He says, the state sent us a letter asking if we wanted to settle the case or not. Oh, so you guys, this is some of the stuff that may be in them sealed documents that we're not allowed to see, right? Archibald just blew it out of the water here, saying the state sent us a letter asking if we wanted to settle the case or not. So if that is true, I was dead wrong with what I said. I said, I cannot see the state ever offering them a plea deal. Ever. What do you guys think about that? About the state? He said the state sent us a letter asking if we wanted to settle the case or not. So that's just to Jim Archibald. Now, I don't know if John Pryor got that same letter asking if they wanted to settle. He says, I took that to my client and she said, what does my husband think? She is married and that's why I filed the motion. Archibald says the state has it in their interest to settle due to high cost of trial. If we don't settle, then it goes to trial. Okay, so the judge is going to put his 2 cents in here. Oh, yeah, I'd love to be sitting right in that courtroom. Okay, so Judge Boyce says, I understand the rationale for this request as it would be efficient for the defendants to talk to each other for a variety of reasons. The concerns raised that the court really shares are the defendants inadvertently waiving privilege. That is the client-attorney privilege, because then that goes out the window, and then the state could then call each lawyer as a witness to what was said in that meeting. Yeah, I don't know, Gene P. That's a good question. That's a really good question. And it looks like the judge, you guys, is making decisions now. He's not taking it under advisement, nothing. He is deciding on these motions right now. Like, he wants to get this court case going, right? He wants this in front of a jury. He wants the case to get going after all these delays and everything else. He wants to get going. He also knows that Lori Vallow, her clock is ticking because her case could get thrown out, right? If they do not give her right to a speedy trial, and they want to keep these cases joint. No, a confession's never going to happen, Marie Burks. And hi, Marie. Nice to see you. Yeah, so the judge is taking into consideration the concerns that were raised by the prosecution, where, like I said, this opens it up to each lawyer being called as a witness against the other defendant. So let's see, you guys, what he's going to decide here. Okay, here we go. Boyce denies the motion for Lori and Chad to meet. Good. Expresses both security concerns, not having a deputy in the room with Chad and Lori, and says it's an idea that is full of pitfalls. I can't talk today, you guys. Please forgive me. That would far outweigh any conveniences. So, with that being said, you guys, they can talk to their lawyer, who in turn can talk to the other lawyer, and that's all privileged. Okay? So if Lori has something to say, she can tell her lawyer, who in turn can talk to Chad's lawyer. He can ask Chad. Chad can give John Pryor his opinion, and Pryor can go back to Archibald with it. You know what I mean? So there are ways around it if they really wanted to do something like that. But the judge is denying any motion for Lori and Chad to meet in person, and he's expressing all the security concerns regarding that, because they didn't want to have a deputy in the room. They wanted no cameras in the room, and they wanted no audio. So no audio, no video recording of it. So they could have conspired a little bit more. You know what I mean? Okay, so Chad Daybell is now being escorted out of the courtroom for the remaining part of the hearing, as the remaining motions don't concern him. He walks quickly out with John Pryor right behind him. He does not look at Lori at all. She chats with her attorney as Chad walks out. So there's a brief recess. So what do you guys think so far? I'm really happy that the judge is making the decisions right now instead of taking it in under advisement, which means we wouldn't hear until sometime down the line. And then does it get put into the court dockets? Do we get to see it? We're hearing about it. So Chad is leaving. The rest of the hearing does not include anything, I guess, to do with him. So they're going to be taking on Lori's other motions. So as we know right now, the judge denied a continuance. The trial is going forward in April. If on the eve of the trial, the defense, John Pryor, can prove that there's exculpatory evidence that they haven't gotten yet, then they will separate the trials, is basically the understanding I got from that. But he's not going to make that decision until the day before trial is supposed to start. What else did we get a ruling on? They are not going to sequester the jury. We got a ruling on that, although the prosecution wanted the jury sequestered for the whole trial. That isn't going to happen. We got a ruling on this little powwow, this little love nest powwow that Lori and Chad, we don't know so much about Chad, because by the way John Pryor was talking was he wasn't in agreement with it at all, because then him and Archibald could have been called as witnesses, to which each other's clients said. So that was denied. No powwow for them. So now Chad is gone, and now they are going to continue with the rest of Lori's motions. Yes, Kelly B, me too, hon, me too. Okay, so Lori's attorneys are expected to argue why they believe the death penalty should be taken off the table when it comes to Lori. Okay, so Jim Archibald, which is Lori's attorney, it's only going to be Lori's attorneys now in there, you guys, and the prosecution, because she's fighting for her motions now. So Archibald is arguing the motion to declare death penalty unconstitutional. He says it's a standard motion filed by death penalty lawyers nationwide. We understand trial courts usually deny our motion and leave it for the appellate court. Gene P. Boom, boom, boom. Let me just get back over to StreamYards here so I can put your comment up. Thank you again, Kelly B, for your super sticker. I couldn't be happier right now since the day the cameras are removed. Now they're fighting for the cameras to be, not only are both defense attorneys wanting the cameras back in the courtroom for the trial, the media is also fighting for them to be able to cover it. Thank you, Melmac. Good to see you. It's just Q. Okay, so let me get back over to here. Kimmy, I hope they fry her. Okay, so let's get going on this. Okay, decisions about the death penalty are routinely flawed. This is Archibald. Okay, so he's fighting this for his motion here. Jurors, humans, are subject to error. They sometimes make decisions in death penalty cases prior to even hearing the mitigation. There is a bias in the jury selection. The instructions to the jury are complicated. Wow, so's killing your children or being part of the deaths of your ex-husband, Chad Daybell's wife. I think all of that is complicated, and maybe you should have taken that into account before you conspired to kill all these people, right? Let's not mention any other channels here, you guys. Thank you, Kat. So it's like Archibald, you know, there's a bias in the jury selection. The instructions to the jury are complicated. Well, so is presenting to the jury why these people lost their lives. It's all complicated. There's nothing simple about this. So it's like, Archibald, what are you thinking? He says, as a death penalty lawyer who has done many of these cases, we try to settle before we get to trial. Some death penalty lawyers would say, if you're already in trial, you've lost because the jury is prone to convict. The jury is basically given a license to kill. Wow. Like, he's calling any potential juror at this point stupid. That they can't base an opinion on the facts that are presented in the case. I don't like this at all. This comments that he's just made. Like, I'm a death penalty lawyer who has done many of these cases and I try to settle. Well, maybe it's because you're not death penalty qualified, or just because you don't win your cases because there's overwhelming evidence of what happened. Are you going to try and use that and say that the jury is stupid? Anybody chosen for jury could be stupid? Like, he says, because some death penalty lawyers would say if you're already in trial, you've lost because the jury is prone to convict. What? Who's biased here? He is. I've never heard a lawyer, in all the lawyers I've worked with in 30 years of working in the criminal justice system here in Canada, I have never heard a lawyer say this. You are turning any potential juror against you right now. Was this intentional? You know, I'm leaning right now towards him intentionally trying to bias any juror that could be called in this case by basically saying that they would not be smart enough, impartial enough, anything along them lines to give their verdict based on the evidence that they hear. You, in fact, Mr. Archibald, just said that you don't believe a jury could be impartial. You know, like, there's so much that he just put forth with what he just said. He is prejudicing any juror member that could hear or see what this just said, what he just said. You are making potential jurors angry with what you just said, because you're basically calling them stupid and impartial, that they already have their minds made up. You know, and you've done many cases. Wow. I wouldn't want you. Not with that. You just put a big thorn in the middle of all this evidence and paper. Like, it doesn't even have to be heard at this point. They're already prejudiced against you because of the comment you just made. Blake argues, okay, so Blake is getting up again. Blake argues against the motion to consider the death penalty unconstitutional. Boyce says it's a technical motion, 60 pages worth of technical motion, and he will take the order under advisement. No ruling today. Wow. So it's the first one that he is going to take under advisement. Okay, so now they have the other one that he's going to argue that Idaho's capital punishment is unconstitutional. That was another motion she filed. Okay, so Archibald now is arguing okay, so he's arguing that the Idaho capital punishment is unconstitutional. He's arguing if Idaho is successful at getting a jury to kill Lori Daybell, will she really be killed? History says no. We are pursuing a punishment that will not happen. What? What? Did this guy not have his coffee this morning? What? He said, like, this guy is off the wall right here. He's arguing that Idaho's capital punishment is unconstitutional. He's saying if Idaho is successful at getting the jury to kill, which means sentencing, I can't talk, sentencing her to death, will she really be killed? Well, she there's the spirit side aspect of this that we could get into, Mr. Archibald, and I would gladly sit down and talk to you regarding that. But the way he is putting it is she really dead? Yeah, she dead. She dead. Bye-bye. Buried 6 feet under, like she did with her kids. You know what I mean? Come on. Think about that.
Like, are you, oh my God. This is, I don't know what he's thinking. I don't think he had his Cheerios or his coffee this morning. Maybe his car got stuck in the snow. He's really pissed off, not thinking clearly. I don't know what he is thinking right now. If Idaho is successful at getting a jury to kill Lori, which in other words, sentencing her to death, will she really be killed? What? History says no. We are pursuing a punishment that will not happen. Well, Cat H, I get what you're saying there, because sometimes there's appeals after appeals, and she could sit on death row forever. But no, that death sentence that she receives, unless she wins an appeal, is there, and it will be carried out as soon as all her appeals run out and everything else, unless she gets a pardon from what do you call them, the person of state there, the governor general or whatever it is there. What? There's a death penalty for a reason. The governor. Okay, she could get a stay by the governor. No, she not. You killed your children. You were part of killing your children, your ex-husband, your new husband's wife, and Lord knows who else. Oh my God. This guy's Looney Tunes. He needs to go back to the circus. Okay. Archibald, which is Lori's lawyer, is going to read the names of 8 people currently on death row, including some who have been awaiting death for 30 years. Why does Idaho seek to kill someone when they do not have intentions of carrying it out? Our process is flawed. It's repellent with mistakes. Wow. He says the appeals process will go on forever if the state receives its wish of the death penalty in this case. That is why I'm asking the court to stop this nonsense now and declare Idaho's capital punishment unconstitutional. Well, you're talking to the wrong judge, because this judge cannot declare Idaho's capital punishment unconstitutional. You have to go to the higher ups, and there's a series of things you need to do to get that done. So Rob Wood now is saying that he notes in the past 5 years he has only asked for one death penalty in one case. This one says that it's rare to ask for it. Okay, so again, Judge Boyce is taking it under advisement. He's going to issue a written decision on the motion. Again, he states that it's another technical motion, so he's going to have to look through it. Well, this has been on your books, Judge, for months. Why haven't you done that? You started off so good today with giving your answer. But no, this one is being taken under advisement too, and he's going to issue a written decision on the motion. This is crazy. Okay, so John Thomas, which is Lori's other lawyer, is going to be arguing the next motion that Lori has filed.
So John Thomas is the one, you guys, if you're just, getting in on this here. John Thomas is the one that had to be hired alongside of Jim Archibald because he is death penalty certified. Death penalty case certified, I should have said. Okay, so John Thomas is getting up and he is arguing the motion that Lori Vallow Daybell should not be eligible for the death penalty. Colleen, as far as we know, it is still going forward, at least absolutely 100% sure that Lori will be going forward on April 3rd. Now, is this case going to remain joined? It's going to all depend on these. If you watched my video 2 days ago, I came out with the new evidence that they found, these hairs. As long as the prosecution can get them the results of if there was any DNA or anything like that found in those hair samples, to bring it up now, it had to have been found somewhere that could be very bad for the defendants, or it could be very good for the defendants. So if it's exculpatory, they have to get that to the defense right away so this trial can start in April. Because come April, the day before the April 3rd trial date, if the defense feels that there's exculpatory evidence that they have not had time to go over or dissect themselves or have evaluated themselves, whatever they come up with, then this trial will be separated and it will no longer be joined. So that's going to be interesting to be watching for that. So the judge, smiling is contagious. The judge denied Chad Daybell's motion to continue. He wanted it put off for another year. The judge says absolutely not. They are going forward with April 3rd date. They have to go forward at this point. Like I explained at the beginning of this, you guys, they have to go forward with that date with Lori, because if not, because she didn't waive her right to a speedy trial, that puts them in the position where the defense could file to have this all her charges dismissed, thrown out, because she did not have her speedy trial. So either way, Lori is going to go forward on the 3rd, unless she does something to hold that up. If she all of a sudden waives her right to a speedy trial, so she can be tried with Chad, then that's a whole new ball game. But as we stand right now, she is still adamant about her speedy trial rights. She is not going to waive those rights, as we know right now. So it's going to be interesting coming close to the court date as to what is actually going to happen. Okay, so John Thomas, which is the death penalty certified lawyer, case certified lawyer for Lori, is arguing this, and he says they filed a motion to declare Lori Vallow ineligible for the death penalty for several reasons, including saving the state time and money. Whoa. Hey, Thomas, John Thomas, your main concern is saving the state time and money. My main concern is getting justice for these innocent children and innocent spouses that were murdered. Dumbass. Oh, some of this pisses me off. I'm sorry, you guys. He goes on to say, we don't believe the state is going to be able to prove Lori was a major contributor to the crime. We don't believe Lori actually participated in any of these events or that she even knew about them. She didn't anticipating them happening and certainly was not a participant. Remember 2 days ago, we just went over the paperwork where she brought up her alibi, that when JJ and Tylee were murdered, she said that she was elsewhere with Melanie Gibb and all them. And then when Tammy was killed, she was in Hawaii with other friends. Like, this is crazy. Well, they've got her with conspiracy to commit murder too. So conspiracy to commit murder also carries the death penalty, especially with those murders being carried out. Even if they were in a conspiracy, I'll explain this a little bit. And I know this is the way it is in Canada. I think it's pretty close, or if not the same in the United States. If you conspire to commit a murder, even if that murder is not carried out ever, you can still face a felony charge, and you will face a felony charge with conspiracy to commit murder, and you could face life in prison. Now, if you conspire to commit murder with somebody, in this case, Lori and Chad, and Lori changes her mind, but Chad still carries out the murders, and this is just hypothetically, you are still held as liable as if you did the murders yourself. So you are going to get the death penalty. Whether you did the murders or not, you conspired to do it, the murders were carried out, and now you are held just as responsible as the person who murdered those who were murdered. And if you guys remember way back, like a year ago, I said that there's going to be a little bit of a problem with putting Lori there, because we've never seen evidence that Lori's phone was ever pinged in that area around the time of the murders. We don't have her phone pinging in that backyard where the bodies were buried. We have phone calls or text messages where Chad is texting Lori around the time of when the children were buried in the backyard and when Tammy was killed. That says that she wasn't there. I get it, but that does not get her off the hook. If they can prove that she conspired to commit these murders and then the murders were carried out, she is fully responsible as if she committed them herself. So I don't know where he's going with this, but they also say she didn't anticipate them happening and certainly was not a participant. Well, you're a participant when you, like she did say some comments about JJ becoming a zombie and this and that. And we all know what her explanation of zombies, if somebody's become a zombie, what you got to do with them. And then she said the same thing about Tylee. And we all know what they do or what they feel with what they have put in their own writings, that if somebody becomes a zombie, it's not really them, and you must kill that physical body to eject the zombie or demon or whatever that's in them, that you're not really killing your child. And if this is the warped sense of reality that she thinks she's going to be able to use in this to get her off a death penalty case or to get her out of any charges, she's sadly mistaken. Oh, I do totally believe that she would have had, Chad would have been next on her list. Oh yeah, she's definitely nuts for sure. Right? Like, and Deborah, that's going to be a lot of the prosecution's case is like, well, since when does a mother not care where her child is? Why didn't you report your child missing if you did not conspire to do this or had no knowledge of it happening? Where did you think your children were? And if you guys remember right back to the very first couple of reads that I did on this case, there was one that I did, now this is going back 2 years ago, where I said they're going to turn on each other. Chad's going to turn on her. He's going to be the one to turn away, and she's going to be baby, baby, baby. You can go back and see them reads. And a lot of people thought I was nuts at the time. Your reads are crazy. But look at what's happening. When stuff like this comes out, you guys, you got to go back and look at my reads. And I'm not trying to, oh, you're bragging. No, I'm saying because I got a lot of flack on that. Go back and look at the reads. Go back, even with the Idaho 4 case. Go back to the read that I did just over a month ago, 3 weeks before the arrest, and see what came out in that read. Go back to the one that I did 2 days after the murders. And I've said right from day one that Kaylee was the target. Look what's coming out. There's so much that came out in those reads that are now coming out now, even the order in which they were killed. Where people, you're crazy and this and that and blah, blah, blah. Well, go back and read it. It speaks for itself. Yeah, Kimmy, exactly. She's saying, they're safe with family. Yeah, safe in heaven. Away from the crazy likes of you, Lori. That's where they're safe. This is crazy. Okay, so let's get back to this. Oh, Archibald. Archibald is getting back up, and Archibald is gonna be chit-chatting with us. Idiot. Okay, so Archibald now is saying that, arguing this is the final motion, you guys. He's saying that this is an objection to getting rid of jurors who say, yes, I'm opposed to the death penalty for personal reasons. So he thinks that there's just going to be people aren't going to want to sit on this jury. And because it's a death penalty case, he says that they're going to be excluding anybody. He said this is what he thinks the prosecution is going to do. He didn't say that, but this is what he's saying in a roundabout way, is that that the DA is going to just object to anybody and get rid of jurors who say that they're opposed to the death penalty for personal reasons. And that also gives the jurors, people who have been selected for jury duty, that would also give them an out if they didn't want to sit on this jury. Would be like, I'm opposed to the death penalty for personal reasons. That's all they have to say, and they're excluded, right? He says they're automatically disqualified. What does that do? It causes juries to be more conviction prone. So, this is their last argument of the day, you guys. This is what he's arguing right now. So this should be over shortly. I think that this argument here, the judge should rule on right away. If he takes this under advisement, there's a problem. Wood got up and responded to Thomas. He says, I'm not going to get into the evidence of the case. Sufficient to say a grand jury has found probable cause that she did commit these crimes. She intended for her children and Tammy Daybell to die. The state can prove that. So, Boyce is taking the motion under advisement and will issue a written ruling. So now that's when Archibald he's still fighting this motion on the death penalty, that he's objecting to getting rid of jurors who say, yes, I'm opposed to the death penalty. He says half the states in the nation have done away with the death penalty. Why? Because standards of decency change over time. Standards in our communities change over time. Well, the one standard, Mr. Archibald, that's never changed is you don't murder anyone, especially your children. That standard in our community has not changed over time. And if you do, and I'm a firm believer in an eye for an eye, I feel, and like I said, even here in Canada, I wish a lot of our criminal law would adapt some of the US's laws, because it's so lax here. It's like unreal. It's laughable at times. But if you're going to, killing one person is bad enough, but 4 and 2 of them are your own flesh and blood, my dude, no. You want to talk about standards in our communities and how they change over time? Well, I don't think this one will ever change. And I don't think the standard of not killing anybody will ever change. Wrap your head around that one, Archibald. And oh, frig, here we go. In a state that's fiscally conservative, it's not very physically conservative to have the death penalty. Okay, so now you're bringing politics into it and costs. Like, we don't like spending money here. We're more conservative here. And it's not very conservative to have the death penalty. It's not fiscally conservative. What? Who says that? Jeez. Jesus. Come on, Rachel, get up there. Well, Sarah, he's arguing this to the wrong judge. This judge is not in a position to be able to change the death penalty, for the state not to have a death penalty. Sorry, Alma, you can't say that word K with the K. You can do a K, and if you want to re-put it up, a K with a star or something, and then the LL, but we don't, that will get me a warning, so I can't do that. Okay, Rachel, my girl. She says, this is the prosecution. This is Rachel Smith. Alma, you can say the K word, but instead of putting an I, put like a $sign or a star or something, so it's not the full word. Gene P. Let's watch that K word, please. Come on, you guys, let's mask those words, please. I don't want to have to remove your comments. Thank you, Kat. Here you go, Melmac. Oh, you guys are great. Shining Bearable. Great comment. Where is that? Hang on. I got to go over here to put it up. Thank you. You took the words right out of my mouth, my dear. Exactly. Any way you can mask it, you guys, perfect. Thank you. I appreciate you guys. Okay, Rachel Smith, she basically is saying this motion is really asking the court to almost be a super legislature and set aside the will of the people of Idaho. The law in Idaho is clear that jurors must be able to follow instructions as given and not superimpose their personal beliefs. Remember what I said earlier when the way Archibald was talking as if potential jurors are just stupid? You know what I mean? And again, you guys, Judge Boyce is taking that under advisement. So that he's not going to rule on that either. He's going to take it under advisement, and he's going to issue a written order. He's back to, I think he was getting, I think his little gavel with denied. I need to get him one of those easy buttons. You know what I mean? You ever see that commercial for Staples? The easy button? Boom! Smash that easy button. Yeah. He was doing so good at the beginning. Denied. Goodbye. And then it was like under advisement. And it's like, it's not like he hasn't had all this paperwork for what Lori filed her motion on. You've had all this paperwork since October. Why do you need to take it under advisement? Unless there is something that they have just argued right now. It's like, I would like to take under advisement, Judge Boyce, please, if you can hear me, please take this under advisement. Check on Archibald. I don't think he's well. I'm just going to leave it at that. I don't think the man's well. Like, you just slandered your potential jurors. You called them basically incompetent and stupid. Wow. Like, nothing like setting up for a conviction for your client and getting people hating you even more than they already do. Under Your Scar says, yep, I bought my boss one at Christmas 2011. Loved it. It's on his desk. Yeah, easy button. Boom. I agree, Gene P. Rachel Smith doesn't get up and speak often. It's usually Lindsay. But when she does, she's like basically giving you a lecture without giving you a lecture. He overexerted himself today with the denies. Yeah. Sarah Adams, it was a figure of speech. It's like he's not well. With some of the comments that he made today, it was like I was dumbfounded. Yeah, the Morphew case, I don't know where that's going, you guys. I still say he is guilty as hell. And the district attorney in that case, I said it right from the beginning when she went on that we're not going to mention the man, the ex-law guy that now has his own big channel that decided to have her on panel. And I said, that's absolutely wrong on so many different levels. I put a comment in his chat and was blocked. I said, this is wrong on so many different levels, and the defense is going to use it against you. She should not be talking about this case, and these are all questions regarding this case. She's the DA on this case. You can't talk about just in general when people are directing a question directly to the case that you are prosecuting. You know what I mean? And I said, it's going to cause problems. And what did it do? It caused problems. I was told by this ex-cop or FBI, whatever he is, and it's not the one with the funny speech. It's his friend. But we're not going to put their name in chat, please. I was basically told by him that I didn't know what the hell I was talking about, to stay in Canada, and they blocked me from the channel. Well, I was right then too. It's like, it's when you got stuff in front of you that is so clear to see. And at that point in time, the channel wasn't really that big for clicks and views and to boast your channel. Absolutely not. Absolutely not. No. I would rather have a very small, intimate channel like I got and keep it classy than to ever go to those lengths to help get this guy off. And that's exactly what it did. It helped get him off. Now, mind you, those charges can be brought back at any time. They were dismissed without prejudice, but Gene P says they block you when you're right. Yeah. Well, Glamady says they were threatened by your intelligence. I mean, everybody knows that. This DA who botched this case from the beginning should have known better without even second guessing it. That's a no-no. That's law 101. So that leaves me to really question other things in that case. Were you really on this case to get him convicted or to get him off? Because the things that she botched in that case, you guys, is unprecedented. Letitia, I've been checking on her. Letitia is back in court. Let me get my Googles on. March 9th, they're going to have a pretrial readiness for her. And the trial starts March 20th, and that is a go. That's a go. So she will be going for a pretrial, I believe, what did I just say, the 9th. And then the trial starts on the 20th. And that is all good to go, you guys. Yeah, especially these. There is one channel that I watch when I have time. I don't have a lot of time, you guys, to watch other channels, but I do try and go and support the ones that support me. You'll always see me on my brother's channel. I'll always support him. There's other channels that I do support. So so when I do have a little bit of time, don't forget, you guys, this takes a lot to go over this stuff. Like, look at, we've been here, what, an hour and a half. I'm trying to, no, Alma. No. Sorry, I didn't allow that comment. She says, what's his channel? We'll go and harass him. No, I don't want any of that. You know what? I believe in karma. Willow, what's your brother's name? AK Rocks. You can go over and check out what mods are still in here. Oh. Cat 8, are you still in here? I can put, hang on, let me get the link to his channel for you. And he is Elma. If you have not checked out his channel, you're going to go and check it out just in time. I'm going to tell you why. He is about, we've been working on this case since day one together. He is about to drop some bombshells. He is, I'll get the link to his channel because you guys can't put up links. Let me just go and get it for you. So yeah, you have the actual link. My sister is usually here. And she has all this stuff. So I'll get you the exact, here you go. There you go, you guys. That is the link to his channel. Go check him out because he's about to drop some bombshells, you guys. He's good at what he does with the behind the scenes, with the GPS and all that. That proves, he can prove exactly where Barry is and where Suzanne could be buried. He goes over it with a fine-tooth comb. He's got drones like you would not believe that can see a pebble on the ground, believe me. And he has been actively searching. He went out with the now defunct Adventures with Purpose to go out and search all the water thing and everything. And I'm not a supporter of Adventures with Purpose, but back then, before we knew all this stuff, he did go out there and search some waterways for us. We had other people that also I was in constant contact with that I had contacting me about certain things, and we would have them go out and investigate it. But since I've taken on a lot more cases, Kurt has really taken over with following through with everything. We did for the first almost year and a half, we worked very, very close. We still work together on it. But he is in depth like you wouldn't believe. That what he does, I could never even fathom trying to even try doing. So he's about to show you guys some stuff. He's about to throw down some truths that a lot of law enforcement and agencies are not going to like. Calamity, thank you so much, my dear, for your super sticker. I appreciate you. There was something else here too I wanted to answer. Calamity, thank you for being a member for 11 months. Thank you so much. Your free thing there, I can't put up on StreamYard for some reason, but I want to thank you so much for being a member for 11 months. Let me just go back through these comments, you guys. Yeah, sick, he's good, people. A lot of people don't like his presentation of how he is, but you know what? You will never find anybody with a heart like his. And when he's got his mind set to something, he will go for the next 20 years. He's never going to give up on this, ever. Ever. Everybody loves his eyes. Yes, he's got the blue eyes. Mine are darker blue. His are like a crystal blue. He's got the most gorgeous eyes you've ever seen. So yeah, go check him out. I put the link here. Hang on. I got to do it over in StreamYard. I don't like bouncing back and forth to StreamYard, you guys, because, okay, I can pin that. I'll pin it at the top here, you guys, for those who want to go and check him out. I'm telling you, you're going to be amazed. Yeah, I'm going to go over the search warrant for Coburg. I'm going to end this live, you guys. Take about 15 minutes, and then I will go over that one if you guys so want. A lot of it, there's 100 pages, but a lot of it is, there's like 42 or 45 pages of just a repeat of the probable cause affidavit. So it sounds like a lot saying there's like 100 pages there. But if you take out the repeats of the probable cause, because they have to attach that to their warrants, it leaves us with probably about 20 pages we'd have to go over. So I can do that if you guys want me to. There's my sister. I told you she knows that right offhand. There she goes. Okay, if you guys do, let me see how many ones I can get. I got 150 people in here. If you want me to show you the search warrant for Brian Kohlberger's apartment and what was found, put a 1 in the chat. If I get enough ones, I will do it. Thank you again, Glamma D, for your super sticker. Inching pieces. Thank you, Willow. You're a good egg, as they say in my Missouri show me state. Oh, thank you. Okay, if you guys want me to do that, okay. So what I'll do is I'll wrap up this. No, Kat, we still have not heard a thing regarding Rosie. Looks like a lot of yous want me to go over that, so I will. Like I said, I'm not going to keep repeating that probable cause affidavit just to make my stream longer, you guys. I'm just going to show you the new information that's come out from the search warrants and stuff like that. So it's not going to be a very long video, probably maybe 45 minutes, just to go over all the new stuff that has come out. Like I said, it's 100 pages because they've attached the probable cause affidavit twice. So that's like 50-something pages right there, like almost 60 pages. No, sorry, 80 pages. So let me get that pulled up, and I will go over that with you. Give me a little bit of time to get it all up and set up for you guys, and I will do that for you. Okay, so with that being said, you guys, I'm going to wrap it up here. I'll get my thumbnail and everything together and get that up on my other screen so I can bring it to you. So I'd say give me about, I don't know, half an hour or so, maybe a little bit longer for me to get that up and ready for you. Okay. Sister is coming to Cali soon. Sister has been dealing with a lot. Oh, I'm good, Kelly B. Thank you, though. Okay, so let's wrap this one up, you guys. Watch for the next live starting in about half an hour or so. Give me a little bit of time to get a thumbnail made, to get this set up and everything, and we will go through that. I'll bring that all to you guys too. I was going to go out and try and grab a few things before this next snowstorm hits, but I got enough to get through for a few days, so it's more important to me to bring you guys the information that you want, and that's what I'm going to do. So with that being said, you guys, this will probably go private for 15-20 minutes. It's uploading to YouTube Studio from my StreamYards. So it will be available. Again, give it about 15-20 minutes and watch for the new stream to start. Okay? So with that being said, you guys, I love you guys to the moon and back. Please take care of yourselves. Please stay safe. Bye-bye for now.